Welcome to Mormon Land, a podcast all about news and culture of the Church of Jesus Christ of Latter-day Saints. I'm Senior Managing Editor Dave Noyce. I oversee the Solid Tribune's faith coverage. I'm joined by Senior Religion Reporter Peggy Fletcher-Stack. Hi, Peggy.
Hi, Dave.
Before we start, here's a quick ask. We invite you to go to patreon.com, where you can access all of the Tribune's faith coverage, podcast transcripts, and the full Mormon Land newsletter. Again, that's Patreon, patreon.com/Mormonland. And if you haven't already, follow us on Instagram at mormon.land. Now for today's show. 2 federal appellate courts, 2 historic hearings, 2 tithing lawsuits, 1 overarching allegation, namely that the Church of Jesus Christ of Latter-day Saints has misled its members, whether about its finances or its history. In one case, prominent former Latter-day Saint James Huntsman insists top church leaders misrepresented how they spent $1.4 billion in the faith's funds to build the for-profit City Creek Center shopping mall in downtown Salt Lake City. Topics ranging from religious autonomy and the U.S. Constitution to outright fraud. And even a Beatles classic surfaced last week before a full panel of judges in the 9th U.S. Circuit Court of Appeals. In the other case, ex-members accused church authorities of hiding important details of Mormonism's beginnings in order to persuade the faithful to pay their tithes. Oddly enough, founder Joseph Smith, his, quote, seer stone, and translation of the faith's signature scripture, the Book of Mormon, were openly discussed before a 3-judge panel of the 10th Circuit Court of Appeals. So where do these lawsuits go from here? What are their prospects? And how do they fit into continued media attention on the church's wealth and potentially expansive class action case? Here to help us sort through this legal maze is Tribune reporter Tony Semerad, who's reported on these lawsuits from the get-go and brought to light other aspects of the church's financial empire. Tony, welcome to Mormon Land.
Hey, thanks so much.
Okay, so Tony, let's start with the James Huntsman lawsuit, okay? Tell us how it ended up in the 9th Circuit Appeals Court in San Francisco and what the judges are being asked to do.
Okay, well, this case has been knocking around since early 2021 when James Huntsman filed it in Los Angeles. It had been tossed out, reinstated, and then finally was taken on appeal by the 9th Circuit. Based in San Francisco, had a hearing on Wednesday, and I would say it pretty much got a little bit of a beating. This is an 11-judge panel that was reviewing the case, and they really peppered attorneys on both sides, but in particular James Huntsman's attorney, David Janellis, on the issue of religious autonomy. Basically getting any kind of legal parsing of this case started. That is, what was meant by tithing? Was tithing used as opposed to something else? What did Gordon B. Hinckley mean when he reassured members in 2003 that tithing wouldn't be used on City Creek? All of those issues veered pretty quickly, according to the judges, into basically the court's reviewing religious topics. What is meant by the word tithing, it turns out, in some judges' minds at least, is really imbued kind of with a religious dimension.
Just the name itself.
Just the name itself. And figuring some of the issues in this case out would involve a kind of a forbidden foray by the courts into religious matters. So that's kind of how it ended up. It was taken after heavy questioning over the course of an hour plus. They took it under advisement. So we should get a ruling in the next couple of months.
Okay. So just quickly, again, you've kind of covered a little bit, and we talked about it in the intro, but what are Huntsman's claims and what are the church's defenses, essentially, in essence?
Well, Huntsman's lawsuit is a fraud lawsuit. He's basically claiming that he was misled into tithing, that he tithed under the impression, tithed during the time that he was a faithful Latter-day Saint. He tithed under the belief that those funds were used for philanthropic purposes for the church's various charitable and religious missions. And along with a number of other people, he claims to have been sort of shocked by the revelations of the IRS whistleblower in late 2019 that revealed that, in fact, church money had gone to City Creek and a substantial amount, $1.4 billion, and then also a church-owned insurance company received
beneficial
life. He's claiming that amounted to fraud, that he was sort of led to believe that tithing wouldn't be used for those purposes, and then it was. His lawsuit cites 5 statements from senior church leaders, including this 2003 statement at General Conference by Hinckley that no tithing funds would be used. And he's proffering those statements as the basis for fraud.
What does the church say in general about defense of this?
Well, so the church's initial defense in this case went to the financial details at issue. They provided somewhat limited financial documentation in the early stages of the case, heavily redacted, that basically showed this money was sidetracked into an account and allowed to kind of accrue before it was used on City Creek. So their initial arguments were based on kind of refuting the specific the actual financial dealings. Right. And the church's argument, of course, has been that not tithing, but earnings from investments, and other commercial ventures, that's where the money sort of came from. And so, his lawsuit hinges on this idea that he kind of relied on those statements. That's why he tied. Then the landscape changed and he wants his money back.
And now the church is arguing something a little different in its defense.
Right. Over the course of the Huntsman lawsuit, there's been a notable shift in gears. The church's attorneys are focused almost exclusively on the idea of religious autonomy. That is, that First Amendment and legal precedent flowing from the First Amendment precludes the courts from deciding these religious matters. And in fact, that came up at the Ninth Circuit level. The judges asked church attorneys why they had focused so heavily on the financial kind of details involved before invoking religious autonomy. And the response from the church's attorney, in that case, Paul Clement, a very kind of high profile attorney that specializes in religious freedom, his argument was, well, the church's first impulse was sort of to clear its name, that church leaders had been kind of impugned by these claims, and that they wanted to sort of dispel and to prove that they weren't factual. And only then did they sort of rely on religious autonomy to sort of
because a church would have some constitutional protection. It's enshrined in the First Amendment, after all.
Right. But there has been a sort of a change in the sequence of legal arguments as the case has gone on.
So you've already mentioned this a little bit, Tony, but what did they press James Huntsman's lawyer on?
Well, he could virtually not get an argument out there at the beginning of oral arguments. As noted in my story, he started by citing the Beatles song, Let It Be, and the lyrics to that song, basically saying that although there were religious connotations to the phrase, Mother Mary comes to me, that in fact, Sir Paul McCartney had written that about his own mom, and that it was a secular statement. And I don't think he got 8 or 9 syllables out before a judge jumped on him, basically saying the judge could think of no context in which tithing wasn't somehow a religious phrase. I think his terminology was a quintessentially religious kind of issue. And then it essentially flowed from there. There was concern as to whether a court would have to decide whether Gordon B. Hinckley was the definitive spokesman for the church, whether speaking at General Conference constituted a sort of a ex cathedra statement. That is, he would be probed on what was meant by this very religious sort of statement that he made over the pulpit. And as I say, Mr. Janellis would try to get these arguments out, but then would be interrupted again by another judge. And it went on for 4 or 5 sort of challenges. And I don't think he ever really got his full argument out that the broader meanings of tithing don't really apply in this case. What's at question here is what Huntsman's motives were, the context in which he tithed. And the argument continues to be there that there is a sort of a secular way to kind of analyze whether he was misled.
But sort of Janelle's point with the Let It Be Mother Mary is he was trying to point out that if the phrase may have a religious sound, but it has a secular meaning by the writer of the song. And so he was trying to point out tithing could be both, right? That was his point.
Yeah, and let's just say it didn't go very far.
It didn't go very far. Okay.
Judges didn't seem to be buying that.
So at the end of the day, what does James Huntsman want?
Well, he is after his own tithing. He wants his own tithing back with penalties and interest. I think it amounts to about $5 million that he's asking for, and he's very specific that he's not trying to prove broader points on this. He doesn't want a class action lawsuit. He's not. He's focused specifically on his own money in that regard. And the court record reveals extensive attempts to kind of negotiate this before it was actually filed. So there was some evidence to sort of take him at his word that that's all he wants.
Can we shift now to the Denver court, the 10th Circuit Court? This is another case. Talk a little about that case and what are the judges being asked to do in that case?
Okay, this is an interesting one. This one's been bubbling around since 2019. Mm-hmm. It's also a fraud case, but in this particular one, a plaintiff by the name of Laura Gaddy, a former Latter-day Saint living in North Carolina now, and a couple of other plaintiffs.
She was a convert to the church.
She was
correct?
A convert,
Mm-hmm.
yes. She's arguing, these are doctrinal arguments, if you will. These plaintiffs claim that specific aspects of the faith were either withheld or misportrayed to them, and that they tithed on that basis and then subsequently learned that those tenets of the church were not true or sort of in question in some way, and they're claiming that that was enough of the elements of fraud for them to want their tithing back. This case has portions of it have been sort of dismissed and refiled, and a kind of a continual process over the intervening years. I think we were on the third amendment complaint by the time Robert Shelby dismissed it entirely. And so the claims in the Gaddy case have sort of been revised as time went on. The initial case had a list of many, many dozens, if not hundreds, of alleged tenets of the church that have sort of
historical claims
since been disproved on some level. By the time it made it to the Denver Court of Appeals last week, the attorneys for the plaintiffs had distilled it down to claims about how the Book of Mormon was translated. And they're claiming that church leaders' omission of the idea that a seer stone might have been used for the translation, that the plaintiffs sort of weren't told that aspect of Mormon theology, and that was an omission that was material to them donating their tithing, and they're asking for that money back. And in a sort of a surprising way, this discussion about the various ways in which the Book of Mormon might have been translated became sort of front and center in the case on Monday, and with judges in Denver asking about aspects of the seer stone, and
no one there an expert on those things, right?
Because this case has been sort of selectively dismissed, by the time it's made it up to the 10th Circuit on Monday, it's essentially a civil racketeering case. The plaintiffs are accusing under RICO, under the racketeering statute, that this material omission, that is, that the fact that they weren't told about the seer stone, constituted fraud. Basically, Laura Gaddy's accusing church leaders of racketeering.
So what are the church's defenses?
Well, in that one, they have also mounted a very strong and consistent church autonomy doctrine. And at Monday's hearing, the attorney for the church, David Jordan, actually sort of sounded like he was a little bit confused at times, saying that, they were making sort of bizarre arguments that the court should inject itself into deciding whether the Book of Mormon was translated from gold plates or translated using a clear seer stone or a brown seer stone. And his argument, David Jordan's argument, basically kind of highlighted to some extent the absurdity under the First Amendment of the church of the courts stepping in and deciding these basic religious matters. And at one point he basically said, who knows what happened in 1820? And that, Gaddy was essentially asking the courts to intrude on the miraculous, was his phrase, that has sort of inject itself into deciding what's orthodox tenets of faith.
So what did the judges focus on in their questions to each of the sides?
Well, because this has come up as a racketeering case, the issue on appeal before the 10th Circuit was whether those beliefs were sincerely believed. In other words, for the church to say certain beliefs are going to be off limits and you're not going to be able to use those in proving fraud, there is a clause under RICO that requires those beliefs to be held sincerely. And so the judges zeroed right in on that and said, okay, look, if let's say church leaders do believe this sincerely, does your fraud case go away? And there was actually sort of a confusing moment for the attorney at that time, because I think the judge was trying to make the case that there was a secular way of trying some of these questions, sort of figuring out, did you leave that out or did you tell me that? But the question sort of fell flat, and Kate Birmingham, the attorney for the plaintiffs, at one point said, yes, her lawsuit would go away if church leaders sincerely believed it. But I think my sense was that she later sort of tried to reel that back.
Tried to walk that back.
And tried to argue for some sort of a secular basis for figuring these things out.
So, Tony, I warned you about this. We know you can't predict what will happen in the two lawsuits, but maybe you can help handicap the cases. What openings do the plaintiffs have, and what hurdles do they face?
Well, it's interesting. Judge Shelby's is now the presiding judge over still a third class action.
He's a federal judge in Salt Lake City.
Federal judge. Mm-hmm. He's the judge that's also heard the Gaddy case up until now, before it went up to the 10th Circuit. And Judge Shelby, along the way, in this sort of process of reviewing amended complaints from Laura Gaddy, he did sort of go down the road to a certain extent of saying that fraud claims in this context, in a very narrow way, could still be heard by the courts, and while still staying away from religious issues. But that path seems to have narrowed very significantly following the hearings last week. Monday's hearing and Wednesday's hearing, judges seem to be noting how difficult this is going to be. And I did put it in my story that the road ahead for these cases does look substantially bumpier now than it did before, and it'll be very telling to see whether plaintiffs, in either case, whether Huntsman or Gaddy and her co-plaintiffs, can actually overcome this sort of religious autonomy shield, and whether there is a sort of a way forward for this kind of case. It's unclear.
We've talked about the Gaddy case a little bit and the things that came up about the Book of Mormon translation. It's interesting, though, that for like I say, they're wading into territory the judges really don't know much about. Historians have written things about this, but that presumably the plaintiff, Laura Gaddy, the original plaintiff, was converted when she heard stories about missionary St. Joseph Smith translated the Book of Mormon, usually said by the gift and power of God, using something called a Urim and Thummim. Apparently that was she believed that, or she accepted that enough to join the church. But when she heard it was a seer stone and that maybe Joseph Smith never looked at the plates really well, he was reportedly translating them. That's too hard it just seems odd. It seems like the court really can't go toward deciding any of that.
Yeah.
They both have mystical origins, right?
Yeah. Well, and there was actually a lot of detail in Gaddy's original case in that regard, and that she said, it was such a common piece of early Mormon art to have depictions of Joseph Smith, reading directly from the gold plates. The church's attorney at one point noted that really all of that is part of the evolution of church doctrine. The early Latter-day Saint that painted those murals had his own interpretation, that others that read the Book of Mormon or that read church lore, and that there is no sort of dispositive interpretation of all of that. At one point it was very telling. The judge in that case specifically asked David Jordan, is there any limit to this? That is the church able to sort of withhold whatever information it might want? The answer seemed to be yes, that the courts could not really put any limit or direct how the church shares the doctrine,
shares its history, or
right.
shares its...
And there may be sort of controversies there that it's not obliged to share, with individual members. It seemed to at least sort of imply a pretty kind of blanket exemption on these things.
So you already alluded to this other case that's now in the federal court. Potentially could be a class action case involving millions of members who pay or have paid tithing. Tell us about that, and where does it stand?
Well, starting about a year ago, October of last year, there started to be what the church referred to as copycat cases. And these overwhelmingly flowed from the IRS whistleblowers allegation. We had 5 of them, starting with one in Utah, 5 of them crop up across the country, all with really kind of similar language and similar claims. And even some of the later cases, almost carbon copies of each other, very, very similar language and allegations, and a kind of a esoteric panel of judges at the federal level called the multi-district litigation panel kind of looked at all these cases, heard arguments from the lawyers, decided to ball them all together and send them back to U.S. District Court. And those are now grouped together in one complaint before Shelby. And I think of the 3 cases, the allegations in this one are arguably the most secular. They really focus on statements that the church makes in soliciting charitable funds, sort of saying, look, these are only going to be used for charity, so please feel free to give. And it's really almost the most secularized version, if you will, of these kind of fraud complaints in terms of what they're basing their fraud claims on. And those have just now been consolidated in front of Shelby. They've started fighting over discovery, like who can look at what. And the church has asked that all that be sort of put on hold until Shelby can decide whether it should be dismissed outright for religious autonomy reasons. And the sort of scuttlebutt in this field is that Shelby might be waiting to kind of see how these cases play out at the 9th and the 10th Circuit before he makes any sort of definitive ruling on the discovery issue. So that's where those stand.
If it got class action status, how does that mean? It essentially means anyone who would have standing would be anyone who'd ever give money to the church.
Yeah.
Correct?
Yeah. Well, see, you raise a really interesting point, because defining a class in a class action lawsuit goes to identifying similarities in their circumstances and in the way they were thinking. And if we're going to have millions of people join this, the church is already sort of raising the issue that, okay, is this a class of dissenters? And is this class of dissenters presuming to represent faithful tithing Mormons who might have these concerns? What does a faithful tithing Mormon do in this sort of circumstance? Do they need to be disaffected to kind of join this class? And is certification of the class asking a judge to probe religious thinking? Right? What were you thinking as a tithing Latter-day Saint, as opposed to another? And what are the reasons for tithing from a religious perspective? It's pretty easy to imagine that running into some legal difficulty just finding the class.
Right. So, okay, even if the church prevails on these lawsuits, they cost time, they cost money, and it could perhaps cost the church in some public image aspects. You already talked about the church worried about leaders being impugned in some of these allegations. And now, you can't prescribe whether, just as an observer and what was been reporting, what could leaders do to avoid these types of cases in the first place? Do you see any kind of thing that they could do?
That's a really interesting question. At the 10th Circuit, one of the judges in that panel raised the question of what would be the problem with additional transparency? What religious issues might be posed? And the church did have an argument that, it couldn't be legally sort of prescribed in any way to say, okay, well, you need to disclose this about your finances as opposed to that. But it did sort of raise the question of, okay, could transparency?
Well, implicit in that question is, would transparency help remedy some of this?
Yeah, would transparency help remedy some of that? The other thing, and these arguments came in the Ninth Circuit hearing, just the difficult dynamics that church leaders face in approaching these cases, and this came up in the context of a sort of a side dispute that's come up on whether Huntsman legitimately lived in Utah or California when he filed his case, and the church's attorney at one point said, the church autonomy should prevent us from having to get into some of these discussions because we were in a position of having to call a former member a liar, question whether they lived in Utah versus California. And so the church is making a pretty convincing argument kind of around the fringes that even like sort of entertaining these kinds of cases is, represents a sort of a First Amendment kind of challenge. So I think that's a very legitimate question as to what could they actually do in these situations, and I'm not sure that there's an answer right now.
So, okay, just one last question, Tony. Rulings could come anytime, but presumably it'll be a while. What should readers look for? Well,
I'm thinking a ruling involving 11 judges is probably going to take a little bit longer than one involving 3. So I think we're probably going to get the 10th Circuit ruling a little bit sooner than that. And the thing to watch there is if it's got any breath of life, right? Or is that entirely shut down by the First Amendment? In the Ninth Circuit, again, that's probably going to take a little bit longer for those judges to kind of figure out where they stand. There are indications that they could not even get to the religious autonomy issue and rule on this in some sort of a jurisdictional way. That is, say, okay, Huntsman actually lived in Utah. We'll send it back to Shelby. He can figure this out. It's always dangerous to kind of try to read the judges based on their questions. There seemed to be some indication that maybe they didn't want to get to that stage of having to sort of sort through the thorny ideas of religious autonomy, and maybe it's just a sort of a jurisdictional issue, and they'll send it over to Shelby, who I'm sure will be very happy to decide all of that.
So I have a question, one last question, and that is, Tony, you've listened to these arguments. How how unusual and odd is it to have these religious debates in a court of law? And do the church lawyers sound like pastors, or do they sound like lawyers, you know?
Well, I have to say, I thought David Janellis and Paul Clement both were incredibly competent in that hearing. This whole notion of religious autonomy is clearly a very hot issue at the appellate and at the SCOTUS, the Supreme Court of the United States level. There is clearly a movement of religious freedom in the new appointees to many of these courts, because a lot of the hottest questions, at least at the Ninth Circuit, seem to come from more conservative kinds of justices. And this, there's reason to think that even in other faiths, that this religious issue, when it comes to, or this religious autonomy issue, when it comes to finances, is a very sort of hot issue right now.
Do you see? You brought this up, but do you see other religions paying really a lot of attention to this and caring? And now, if there are going to be more conservative judges, will we see this happen more, you think?
Yeah. Well, there was reference to two very recent Supreme Court rulings that have sort of shaped all of this in a very meaningful way. There was an employment case where the Supreme Court has essentially come down with a ministerial exception now in religious autonomy. That is, questions of, how ministers are hired and vetted and that sort of thing are now off limits to the courts. And those are entirely religious matters based on one ruling. And then there's another ruling that has sort of sought to generalize that on some level. So the answer to your question is yes, this is closely watched by other faiths. And yes, I think we're seeing something of a little bit of a legal movement here, I think, with these new court appointees. And I think what comes out of these cases is going to be very sort of landmark and lasting with regard to how the courts handle these cases.
Tony Semerad, thanks for joining us.
Hey, thank you.
And thanks for your coverage.
You bet.
Thanks also to Peggy Fletcher Stack.
Always a pleasure.
And our producer, Chris Samuels. We remind you that you can keep up on all the happenings in and about the church by subscribing to the Salt Lake Tribune's free Mormon Land newsletter. Just go to sltrib.com to sign up, and we'll talk again next time on Mormon Land.